What rights do I have to join a union? Have you ever thought about joining a union at work or even starting one, but worried what your employer might do? Maybe you've heard stories of workers being fired, threatened, or told that unions aren't allowed. The question is, what rights do we actually have to join a union? The truth is that under U.S. law, workers have powerful protections. The National Labor Relations Act of 1935 guarantees the right to organize, to join together for better wages and conditions, and to form or support a union. Employers who interfere with those rights can face serious penalties. In this video, we'll explain exactly what the law says. We'll cover what rights workers have under Section 7 of the N.L.R.A, what employers are not allowed to do under Section 8, examples of real cases, and what steps we can take if our rights are violated. 1. The foundation, the National Labor Relations Act. The starting point is the National Labor Relations Act, N.L.R.A, passed in 1935. Its goal was to protect workers' rights to organize and to balance power between employees and employers. Under Section 7 of the N.L.R.A, employees have the right to form, join, or assist a labor organization, bargain collectively through representatives of their own choosing, engage in concerted activities for mutual aid or protection, even if no union is involved. Refrain from these activities if they choose. The National Labor Relations Board, N.L.R.B, is the agency that enforces these rights. If an employer violates them, the N.L.R.B can investigate, order remedies, and even reinstate fired workers. Example: a group of retail employees discusses wages and starts handing out union flyers in the break room. Under Section 7, this activity is protected, even if no formal union exists yet. 2. What employers cannot do. Section 8 Violations. Just as Section 7 spells out worker rights, Section 8 of the N.L.R.A defines what employers are forbidden to do. These are called unfair labor practices, ULPS. Employers may not interfere with or restrain employees exercising union rights, threaten, interrogate, or spy on workers about union activity, promise benefits to discourage union support, fire, demote, or discipline employees for union involvement, refuse to bargain in good faith once a union is certified. Example: a warehouse manager tells workers they'll lose hours if they vote for a union. That's a Section 8 violation. Or, if HR questions an employee about who's attending union meetings, that's unlawful interrogation. Employers often try to skirt the line, holding captive audience meetings where they discourage unionization. While they can express opinions, they cannot make threats or promises tied to union activity. 3. Concerted activity beyond formal unions. An important part of Section 7 is that rights apply even if there's no official union. Workers who act together for mutual aid or protection are protected. Example: two employees complain jointly about unsafe conditions to their boss. Even without a union, this is concerted activity and is protected by the N.L.R.A. If the employer retaliates, it's unlawful. Concerted activity covers discussing wages with coworkers, circulating petitions about scheduling, meeting after hours to talk about workplace safety, posting on social media about shared workplace concerns within limits. The N.L.R.B has ruled repeatedly that employers cannot punish workers for these actions. 4. Real-world cases. Looking at real cases helps us see how the law works. Case 1. Walmart flyers. Workers handed out union flyers in a store break room. Management tried to stop them. The N.L.R.B ruled that distributing literature in non-work areas during breaks was protected. Case 2. Starbucks firings. In recent years, baristas involved in union drives were allegedly fired for minor infractions. The N.L.R.A stepped in, ruling that these firings were retaliatory and ordering reinstatement. Case 3. Boeing threats. Boeing managers suggested that unionizing could lead to plant closures. The N.L.R.A found those statements unlawful because they implied threats. Case 4. Social media posts. Employees of a small business posted complaints about work conditions on Facebook. The employer fired them. The N.L.R.A ruled this was protected concerted activity, ordering reinstatement. These examples show that even powerful corporations are not above the law, and that workers can and do win cases when rights are violated. 5. Limits on union rights. While protections are strong, they're not unlimited. Supervisors and managers are generally not covered by the N.L.R.A. The law applies to most rank-and-file employees. Public employees may be covered by separate state labor laws, since the N.L.R.A applies mainly to the private sector. Certain industries like airlines and railroads are governed by the Railway Labor Act, not the N.L.R.A. Misconduct during union activity is not protected. For example, threats or violence can strip away N.L.R.A protection. Example: workers can protest unsafe conditions, but if they block entrances or damage property during the protest, they may lose legal protection. 6. How to exercise union rights safely. So what can workers do if they want to join or form a union? Talk with coworkers. Conversations about wages and conditions are protected. Distribute literature in non-work areas. Break rooms or parking lots are usually allowed. Hold meetings off-site. Workers can gather outside work hours to discuss unionizing. Contact a union organizer. National unions often provide support and resources. File a petition with the N.L.R.A. If at least 30% of workers sign cards, an election can be held. Report violations. If an employer retaliates, workers can file a charge with the N.L.R.A within 6 months. Example: a group of hotel workers starts discussing forming a union. Management tells them to stop talking about it. They file an N.L.R.A charge, and the board investigates the employer for unlawful interference. 7. The bigger picture union rights are about more than legal text. They're about balance in the workplace. The N.L.R.A was passed during the Great Depression, when workers had little power against large employers. Nearly a century later, the same principles apply. Workers must be free to band together without fear. Today, union drives are rising in coffee shops, warehouses, universities, and tech companies. Employers still push back, but the law provides guardrails. Every time workers assert their rights and win protection, it strengthens the system for others. So, the bigger picture is this: union rights are central to workplace democracy. So, what rights do we have to join a union? Under the National Labor Relations Act, we have the right to organize, to discuss wages and conditions, to join or form a union, and to act together for mutual aid. Employers cannot legally threaten, fire, or retaliate against us for exercising these rights. But protections work only if we use them. That means knowing the law, standing together, and contacting the N.L.R.A if violations occur. Unions are about giving workers a voice. If this video helped clarify your rights, share it with coworkers. The more we understand Section 7 and Section 8 of the N.L.R.A, the more we can protect ourselves and shape fairer workplaces.